London, January 1950. The Old Bailey's courtroom holds a secret that will haunt Britain for decades. A 25-year-old Welsh laborer stands accused of murdering his infant daughter, his fate sealed by the quiet testimony of the man downstairs, a neighbor who speaks with authority, calm precision, and chilling credibility. 2 bodies discovered in a washhouse, 4 confused confessions. 1 man hanged, but beneath the polished testimony and hasty verdict lies a darkness no one in that courtroom could imagine. Within 3 years, the walls of 10 Rillington Place will reveal their true horror. 6 more bodies, a serial killer's confession, and the devastating truth that justice executed an innocent man. This is the trial that exposed Britain's darkest legal failure, sparked a national reckoning, and forced a nation to ask an unbearable question. How many innocent voices were silenced by the machinery of law? Before we dive into this story of justice gone catastrophically wrong, tell us where you're watching from and what happens when the law trusts the testimony of monsters over the confused words of the vulnerable. The morning sun struggles through London's gray winter sky as crowds gather outside the Central Criminal Court. January 11th, 1950. Inside Court Number 1 at the Old Bailey, the air hangs heavy with expectation and the weight of Victorian wood paneling that has witnessed centuries of judgment. Journalists from every major newspaper sharpen their pencils, preparing to document what they believe will be a straightforward murder trial. Gallery observers shift in cramped seats, craning their necks for better views of the dock where the accused will stand. The room smells of old wood, nervous sweat, and the peculiar mustiness that accumulates in places where life and death decisions are rendered with bureaucratic regularity. Outside, London continues its recovery from war, rebuilding, rationing, trying to reclaim normalcy. Inside this courtroom, the machinery of British justice prepares to render its verdict on a case that appears, to most observers, tragically simple and utterly clear-cut. The clerk's voice cuts through the murmur. Timothy John Evans, you stand charged with the murder of Geraldine Evans on or about the 10th day of November, 1949. How do you plead? Evans rises unsteadily. 25 years old, slight of build, his face bears the confusion of a man drowning in words he cannot fully grasp. His hands tremble slightly as he grips the edge of the dock. He looks around the courtroom, at the judge in his wig and robes, at the barristers in their formal attire, at the jury of 12 strangers who will decide whether he lives or dies. Everything about this place intimidates him. The formal language, the arcane procedures, the educated voices discussing his fate in terms he struggles to comprehend. He is a Welsh laborer, barely literate, a man whose entire life has been a struggle against poverty and limited opportunity. Now he stands in the highest criminal court in England, facing a charge he cannot fully articulate a defense against. Not guilty, sir, he says, his voice barely audible, thick with his Welsh accent. Mr. Justice Lewis peers down from the bench, his face drawn, his health visibly deteriorating. He will be dead within weeks of this trial's conclusion, a heart condition that should have prevented him from presiding over such a demanding case. But today he commands absolute authority, his illness hidden behind judicial robes and the formality of office. His voice, when he speaks, carries the weight of centuries of English law. To his left, Christmas Humphreys, senior Treasury Counsel, arranges his papers with practiced precision. Humphreys, prosecutor of war criminals in Tokyo, future judge, and man of Buddhist philosophy, carries the weight of the Crown's case with the confidence of experience and unshakable belief in his own judgment. He believes in karma, in duty, in the inexorable machinery of consequence. He sees himself as an instrument of cosmic justice, delivering verdicts that resonate beyond this life into future incarnations. Today, that machinery will grind an innocent man toward death, and Humphreys will never fully acknowledge his role in one of Britain's greatest miscarriages of justice. His conviction rate is remarkable. His reputation is formidable. His certainty is absolute, and his certainty in this case is catastrophically wrong. Across the well of the court sits Malcolm Morris, Evans's defense barrister. His brief from the solicitors Freeborough, Slack and Company contains enough doubt to plant reasonable questions, but not enough investigation to prove them. The firm's cursory preparation suggests they view Evans as obviously guilty, unworthy of extraordinary effort. They have conducted virtually no independent investigation. They have not interviewed key witnesses. They have not pursued alternative theories with vigor. Morris himself appears competent but not inspired, dutiful but not passionate. He will do his job as the system requires, but without the ammunition of thorough inquiry, He fights with one hand tied behind his back. He has met with Evans several times, listened to his confused accounts, and struggled to construct a coherent defense from contradictory statements and implausible-seeming claims about the neighbor downstairs. Morris knows his client is vulnerable, illiterate, easily manipulated, but knowing these things and proving them persuasive to a jury are entirely different challenges. He arranges his own papers, reviews his notes one final time, and prepares to fight a battle he privately believes he will lose. The jury files in, 12 ordinary Britons tasked with weighing testimony, assessing credibility, determining truth. They are shopkeepers and clerks, housewives and tradesmen, people of moderate education and conventional morality. They look at Evans and see a man of limited intelligence, obvious vulnerability, and suspicious behavior. They see someone who confessed, then retracted, then confessed again. They see someone whose story changes with each telling. They see, in short, exactly what they expect to see in a murderer caught in lies. What they do not see, what they cannot see without information never presented to them, is a man so vulnerable to interrogation pressure that he would confess to crimes he didn't commit simply to make the questioning stop. They do not see the psychological dynamics of false confession. They do not see the manipulation that preceded the murders. They do not know they are looking at a victim rather than a perpetrator. Their faces reflect the certainty of their culture, that police get confessions from guilty people, that respectable witnesses tell the truth, that the justice system works. They do not yet know they are looking at a man the system will fail catastrophically. In the witness box, prepared to testify, sits John Reginald Halliday Christie, 51 years old, former War Reserve constable, a man who speaks in quiet, measured tones damaged by gas attacks in the Great War. He wears respectability like armor, neat suit, polished shoes, carefully knotted tie, the bearing of a man who has served king and country with distinction. His face shows concern appropriate to a man caught unwillingly in tragic circumstances. His demeanor projects helpful cooperation tinged with reluctance to speak ill of a neighbor. When he speaks, his voice requires listeners to lean forward, to strain to catch every word. This physical necessity creates an intimacy, a sense that he is sharing painful truths rather than calculated lies. People listen, people believe. His criminal past, arrest for theft, assault, violence against women, has been largely sanitized by 17 years of apparent good behavior. The prosecution knows about his record but considers it irrelevant, old history overcome by subsequent respectability. They do not know, cannot know, that Christie is one of Britain's most prolific serial killers, that the respectability is camouflage, that the helpful witness is a monster, that the man testifying against Evans is the actual murderer. When Christie lies, people believe. That is his gift, his weapon, his means of survival, and today, he will use that gift to send an innocent man to the gallows. Behind these players stretches a story that began 3 years earlier, when young love collided with poverty, when trust met manipulation, and when the walls of a London tenement became a tomb for innocence. To understand how this courtroom arrived at its terrible verdict, one must understand the path that led the Evans family to 10 Rillington Place, the house that would destroy them. The year 1947 brought Timothy Evans and Beryl Thorley together in the optimism of post-war Britain. The war had ended. Rationing continued, but hope had returned. Young people looked forward rather than back, seeking to build lives free from the devastation that had marked the previous decade. Timothy and Beryl were both young, both of limited education, both hoping to build something stable in an unstable world. Neither had advantages of wealth or family connections. Both came from working-class backgrounds where life was a constant struggle against poverty and limited opportunity. Their courtship was brief, a few months of cinema dates and walks, the kind of romance that flourishes when people are young and hopeful. Their wedding was modest, attended by family and a few friends, celebrated in the simple way of people who have more love than money. When Beryl became pregnant in early 1948, they needed more space than the single room they'd been renting. That need led them to 10 Rillington Place, Notting Hill, a narrow, grimy street of divided Victorian houses where privacy was a luxury and shared spaces bred unwanted intimacy. The house seemed adequate to their limited requirements. The rent was affordable. The top-floor flat had 2 rooms. It would do. The house at number 10 rose 3 stories, carved into separate flats by economic necessity and Victorian architecture. Ground floor, John and Ethel Christie, the quiet couple who kept largely to themselves. Christie worked as a clerk, spoke of his war service with modesty, mentioned vaguely his medical knowledge acquired during his time in uniform. Ethel seemed mousy, withdrawn, forever in her husband's shadow. A woman who spoke little and revealed less. Neighbors considered them respectable, quiet, perhaps a bit odd, but certainly not threatening. Christie presented himself as helpful and knowledgeable, the sort of man who could fix minor household problems and offer advice on practical matters. His past, arrests for assault, violence against prostitutes, theft, was unknown to his neighbors and unmentioned by Christie himself. He had reinvented himself as a respectable citizen, and the neighborhood accepted the reinvention at face value. First floor, another couple, peripheral to the coming tragedy. People who heard arguments from above and below, but minded their own business, as was customary in such close quarters. Top floor, the Evans family, Timothy, Beryl, and in September 1948, baby Geraldine. Their flat was cramped, poorly heated, reached by steep stairs that exhausted Beryl when she carried shopping and baby together. The ceilings were low, the walls thin, the plumbing unreliable. But it was theirs, or at least they rented it, and it represented their attempt to build a family life on limited resources. Life in the top flat was cramped and loud. The Evanses argued about money, about Timothy's employment troubles, about the exhausting reality of new parenthood in conditions of poverty. Timothy worked as a van driver when he could find work, but his limited literacy made many jobs impossible, and his quick temper made keeping employment difficult. He was fired repeatedly for minor infractions, for arguments with supervisors, for mistakes that stemmed from his inability to read instructions properly. Beryl tried to manage the household on irregular income, stretching pennies, making do, slowly drowning in the impossibility of raising a baby on inconsistent wages. Their voices carried through thin walls. Their struggles were known to those below. The sound of Geraldine crying, of Timothy shouting, of Beryl weeping reached the other flats as intimately as if everyone shared the same room. Privacy was impossible. Every argument became public knowledge. Every struggle was overheard. The house itself seemed designed to amplify sound, to broadcast private misery to unwilling audiences. Neighbors heard everything, but said nothing. That was the code of such places. Mind your business. Don't interfere. Let people sort their own troubles. It was a code that would have catastrophic consequences. Christie presented himself as helpful, knowledgeable, a man who understood things beyond the grasp of his illiterate neighbor. He spoke of his time as a special constable during the war with quiet pride. He mentioned medical training acquired in the service, though the details remained vague. He offered advice on household matters, on child rearing, on practical problems that baffled Timothy. To Evans, struggling with literacy and complex thought, Christie appeared educated, trustworthy, perhaps even wise. Here was a man who had served in the war, who had been a police officer, who spoke with authority on medical matters. When Christie offered opinions, Timothy listened. When Christie made suggestions, Timothy considered them seriously. The relationship was fundamentally unequal, the educated man helping the ignorant one, the mentor guiding the struggling pupil. It was a dynamic Christie cultivated carefully, establishing trust and dependence that he would later exploit with lethal consequences. For Christie, the Evans family represented opportunity. Beryl was young, vulnerable, increasingly desperate. Timothy was gullible, easily manipulated, barely capable of understanding complex situations. The combination would prove irresistible to a predator who had spent decades perfecting the art of exploiting vulnerable women. It was a fatal misjudgment on Timothy's part to trust this man, but how could he have known? Christie wore the mask of respectability so well that even police would later find him utterly credible. Timothy Evans, with his limited judgment and desperate circumstances, never stood a chance of seeing through the deception. By autumn 1949, Beryl discovered she was pregnant again. The news landed like catastrophe in a household already strained to breaking. They could barely afford Geraldine. Feeding one child on irregular income required constant sacrifice and creative management. A second child would bury them financially, would make impossible an already nearly impossible situation. There was no money for another mouth to feed. There was no space for another crib. There was no energy left for another infant. The flat that barely accommodated 3 people could not possibly house 4. Abortion was illegal, dangerous, desperate, the option of last resort for women trapped by biology and poverty. But what other option existed? They couldn't afford another child. They couldn't manage the situation. Beryl panicked, seeing her future narrow to impossible choices. Timothy panicked, knowing his irregular employment could never support a larger family. Into their panic stepped the neighbor downstairs, the man who claimed to have answers, the predator who saw opportunity in desperation. Christie told them he could help. He had medical knowledge, he claimed with quiet confidence. He had performed such procedures before. He lied smoothly. He could take care of it safely, quietly, without the authorities knowing. There would be no danger, no pain, no complications. The cost would be minimal, perhaps a few pounds, perhaps nothing at all beyond gratitude. The risk would be small compared to the alternative of bearing an unwanted child they couldn't afford. Trust him, he urged. He knew what he was doing. He had medical training from the war. He had access to proper equipment. He could ensure everything went smoothly. His calm authority was persuasive. His medical claims seemed credible. His offer appeared to be genuine neighborly help in desperate circumstances. For Beryl and Timothy, drowning in panic and seeing no other solution, Christie's offer seemed like salvation. They didn't know, couldn't know, that Christie's medical knowledge was entirely fabricated, that he had no training beyond rudimentary first aid, that his real interest in Beryl had nothing to do with helping and everything to do with satisfying his murderous compulsions. They trusted him. It was the last and worst mistake they would ever make. On November 8, 1949, Christie told Timothy to stay away from the flat for the day. The procedure would be quick, he said with false reassurance. Better if Timothy wasn't present. Medical procedures went more smoothly without anxious husbands hovering nearby. It would be finished by the time he returned in the evening. Beryl would be resting, recovering, perhaps a bit weak but fundamentally fine. Evans, trusting and desperate, complied without question. He left his wife in the hands of a monster, walked out of the flat that morning, and never saw Beryl alive again. What happened in that flat while Evans was away can only be reconstructed from Christie's later confessions and forensic evidence. Christie claims he used a rubber tube connected to the coal gas jet to render Beryl unconscious, his preferred method for subduing victim. While she was helpless, unable to resist or call for help, he strangled her. Whether there was a sexual assault is unclear. The pathologist found evidence suggesting post-mortem interference. Christie's pattern with other victims included necrophilia. Beryl died alone, betrayed by the neighbor she'd trusted, killed by the man who had promised to help her. And upstairs, 14-month-old Geraldine slept, unaware that her mother had been murdered, unaware that her own death would follow shortly. When Evans returned, Christie's expression told him something had gone terribly wrong. There had been complications, Christie explained with false sympathy and carefully manufactured grief. The abortion hadn't gone as planned. These things happen sometimes, despite best efforts and proper precaution. Beryl's system had reacted badly to the procedure. She had hemorrhaged. Her heart had given out. She had died. He was sorry. So very sorry, but these things sometimes happened with such procedures. The risks, though small, were real. Christie delivered this news with perfect credibility. The sorrow of a medical man who had tried his best but lost a patient despite his expertise. Evans stood paralyzed, grief and confusion cascading through his limited ability to process crisis. His wife was dead. Beryl, whom he had loved despite their arguments, despite their poverty, despite everything, gone. And their baby. What about Geraldine? Christie had answers. He always had answers. That was his gift, the ability to provide explanations that seemed reasonable, to offer solutions that appeared helpful, to guide confused people toward outcomes that served his purposes. He would dispose of Beryl's body, Christie promised with quiet efficiency. He knew people who could help with such matters. People who owed him favors, people who could handle things discreetly. He would arrange for Geraldine to be cared for temporarily. He knew a couple in East Anglia who were childless and would love to foster a baby. Timothy should leave London immediately, go back to Wales, stay quiet and wait for word. If authorities discovered what happened, both men would be implicated in illegal abortion. Christie as the provider, Evans as the requester. Both could face serious criminal charges. The best thing, the only thing, was to stay silent. Let Christie fix everything. Trust him to handle the situation. Evans, overwhelmed and barely capable of complex thought at the best of times, certainly couldn't process this catastrophe rationally. He was being told his wife was dead, his daughter would be taken away, he needed to flee, and he needed to trust the very man whose help had led to this disaster. But what choice did he have? Christie spoke with such authority, such confidence. He seemed to know what to do. Evans didn't. So Evans left, carrying grief and confusion and the terrible weight of secret knowledge that would soon destroy him. So Evans left London on November 14th, taking a train back to Merthyr Tydfil, his Welsh hometown, carrying grief and confusion and the terrible weight of secret knowledge. For more than 2 weeks he stayed in Wales, believing Christie's lies about Geraldine being cared for by a couple in East Anglia, trying to process what had happened, struggling to understand how his attempt to solve one problem had resulted in catastrophe. He told different stories to different people. His aunt, his mother, neighbors who asked where Beryl was. The story shifted and contradicted because Evans himself didn't know what truth he could tell. Christie had told him to stay silent, but how could he explain Beryl's absence without raising questions? He said she'd gone to Bristol. He said she'd left him. He said she was staying with relatives. The lies multiplied because the truth was both too terrible and too dangerous to speak. But the weight grew unbearable. The knowledge that Beryl was dead, the uncertainty about Geraldine's fate, the growing realization that he'd been manipulated into something beyond his comprehension. It all pressed down on him with increasing force. By November 30th, unable to maintain the fiction any longer, unable to live with the terrible not knowing, Evans walked into Merthyr Tydfil police station and told a story so confused it immediately raised every possible suspicion. The desk sergeant listened to Evans' halting, contradictory account of Beryl's accidental death from an abortion gone wrong. The story shifted even as Evans told it, contradicted itself in fundamental ways, left gaps where details should be. He said Beryl had taken something to end the pregnancy. He said she'd had it done by someone. He said it was an accident. He said Christie had helped afterward. Each version differed slightly from the last. Each telling revealed Evans' profound confusion about what had actually happened versus what Christie had told him happened. Evans couldn't explain clearly because he didn't know clearly. He had been deliberately deceived, kept away during the crucial events, fed lies about what occurred. He couldn't write his own statement because he was functionally illiterate. He could barely follow the questions being asked because the formal language of police interrogation exceeded his comprehension. The desk sergeant, hearing this confused mess of contradictions and evasions, immediately suspected Evans was hiding something far worse than an abortion gone wrong. He sensed deception, not realizing that Evans was deceived rather than deceiving. The police, sensing something deeply wrong and potentially criminal, placed Evans under caution and arranged his transport to London for further questioning by detectives experienced in murder investigation. At Notting Hill Police Station, detectives subjected Evans to hours upon hours of intensive interrogation over multiple days. Detective Inspector James Black and his colleagues were experienced interrogators who knew how to extract confessions from resistant suspects. They questioned Evans in shifts, coming at him from different angles, testing his story for inconsistencies, pressing him on details, wearing down his resistance through exhaustion and psychological pressure. Evans was exhausted from travel and stress, frightened by the formal police environment, barely literate enough to understand the legal terminology being used, completely out of his depth against trained investigators who had dealt with hundreds of suspects and knew every technique for breaking down denials. His statements shifted depending on who asked questions and how they asked them. Sometimes he said he'd killed Beryl himself in an argument. Sometimes he implicated Christie in the abortion that went wrong. Sometimes he claimed accidents or self-defense or panic. The detectives, convinced they were dealing with a murderer trying to escape responsibility, shaped these confused utterances into formal statements that would later appear calculated and damning. They told him Christie had said certain things, manipulating Evans by suggesting his neighbor had already betrayed him. They pointed out contradictions in his accounts, not recognizing these contradictions stemmed from confusion rather than calculation. They suggested that confession would make things easier, a standard technique that can lead vulnerable suspects to confess falsely just to end the unbearable pressure. Evans signed statements he couldn't read, agreeing to narratives he didn't fully understand, essentially cooperating in constructing the case that would hang him. The interrogation was technically legal under 1949 standards. The judge's rules that governed police questioning had been followed in the letter, if not the spirit. But those rules provided minimal protection for someone as vulnerable as Evans, someone who couldn't read what he signed, couldn't fully comprehend the legal implications of his words, couldn't distinguish between helping police understand what happened and incriminating himself in murders he didn't commit. Modern understanding of false confession psychology would recognize all the warning signs: vulnerable suspect, prolonged interrogation, shifting narratives, inability to provide consistent detail, suggestibility to interviewer prompts. But in 1949, confessions were considered reliable evidence of guilt. If someone confessed, they must be guilty. That was the operating assumption. The possibility that an innocent person might confess to end psychological pressure, to please authority figures, or out of confusion about what actually happened, was not seriously considered by investigators or courts. On December 2nd, police conducted their first search of 10 Rillington Place. It was cursory, superficial, the kind of search that assumes what it will find based on preconceptions about the case. Officers asked Christie about the wash house, The cramped 4 by 5 foot structure in the back garden where Evans had vaguely indicated bodies might be located in one of his confused statements. Christie, calm and cooperative, said he'd noticed nothing unusual in that space. He explained that he and his wife used the wash house regularly to access the water supply. Surely they would have noticed if anything were amiss. Ethel Christie corroborated her husband's account, claiming they went in and out of that tiny space daily without detecting anything out of the ordinary. Police, faced with the authoritative testimony of a former constable and his wife, accepted these assurances and concluded their search without discovering anything. They examined the wash house briefly, saw nothing obvious, and moved on. The timber planks stacked in the alcove seemed unremarkable. The configuration looked like builder's materials left behind after work. Nothing about it screamed concealment. The officers conducting the search had no particular reason to suspect Christie. He was helping them, after all, answering their questions cooperatively, providing useful information about the Evans family's troubled relationship. He seemed like exactly the sort of respectable neighbor who would assist police in their investigation. The idea that he might be lying, that he might be the actual murderer, that the helpful witness might be concealing 2 bodies mere feet from where he stood answering questions. It simply didn't occur to investigators whose focus remained fixed entirely on Evans as the obvious suspect. But doubt nagged at the investigators. Evans' story, however confused and contradictory, pointed too specifically to the wash house. He had mentioned that location repeatedly across different statements. Could he have invented that detail out of nothing? Could mere confusion account for such specific geography? The senior detectives reviewing the case decided a more thorough search was warranted. On December 8th, they returned to 10 Rillington Place, with renewed determination to examine every inch of the property. This time they moved beyond cursory glances and polite acceptance of Christie's assurances. They examined the sink alcove closely. They studied the stacked wood with attention to how it was configured. They moved planks aside to see what lay behind them. They followed their instincts about that confined space. And there, in the shadows behind timber planks that had been deliberately arranged to conceal the alcove, they found horror that would shock even experienced homicide detectives. Behind the wood lay the bodies of Beryl and Geraldine Evans, mother and daughter murdered and hidden with deliberate care. Both had been strangled. Beryl with a ligature around her neck, Geraldine manually with hands that crushed her tiny throat. Both had been concealed with planning and forethought, the timber arranged to hide them from casual observation. The discovery sent shockwaves through the investigation and the broader Metropolitan Police. 2 murders, carefully hidden in exactly the location the confused suspect had indicated, found only after a second, thorough search of premises that a former police constable claimed to use daily without noticing anything amiss. The implications were staggering, but investigators didn't follow those implications to their logical conclusion. Instead, they interpreted the discovery as confirmation of Evans' guilt. He had told them where the bodies were because he had put them there. The fact that Christie had somehow failed to notice 2 decomposing bodies in a space he claimed to use regularly never became the focus of serious suspicion. Christie remained, in police eyes, the credible witness rather than a suspect. That investigative failure would prove fatal to Timothy Evans. Evans was formally charged with murder on December 9, 1949. The Crown, following prosecutorial strategy that prioritized conviction over comprehensive justice, chose to try him only for Geraldine's death rather than charging him with both murders. The murder of an infant was unambiguous, unmotivated by any conceivable provocation, cold-blooded in a way that eliminated possible defenses. A wife's murder might involve arguments about domestic violence, provocation, manslaughter rather than murder. But a baby's murder? There was no mitigation, no possible excuse, no way to reduce the charge. It was murder in its purest, most condemnable form. The strategy also allowed the prosecution to introduce evidence about Beryl's murder without having to prove it beyond reasonable doubt. They could present it as background, as context, as evidence of a single murderous act that encompassed both victims. This legal maneuvering maximized the chance of conviction while avoiding complications that might arise from having to prove both murders to the jury's satisfaction. The charge was murder. And murder in 1950, Britain carried one sentence mandated by law: death by hanging. There was no discretion, no possibility of life imprisonment, no judicial flexibility. If the jury found Evans guilty of murder, he would hang. The only question was guilt or innocence. The verdict would be binary, and the consequences would be final. The trial opens with ritualistic formality. Mr. Justice Lewis enters to the command of "All rise." The jury is sworn. Christmas Humphreys rises to deliver the prosecution's opening statement, his voice measured and confident. Members of the jury, this is a case of domestic tragedy turned to domestic horror. The Crown will prove that Timothy John Evans, in a fit of rage and desperation, murdered his wife and infant daughter in their flat at 10 Rillington Place. We will show you his confessions. Not one confession extracted under duress, but multiple confessions, given to police at different times, in different locations, to different officers. We will present testimony from the investigating officers who discovered the bodies, exactly where Evans said they would be located, hidden in exactly the manner Evans described. We will call John Christie, Evans's neighbor and a former police constable, to whom Evans confessed his crimes shortly after committing them. We will introduce forensic evidence from the pathologist who examined the victims and determined the cause and manner of death. The evidence, ladies and gentlemen, is overwhelming and mutually corroborating. This is not a case of mystery or uncertainty where the jury must guess at what happened. This is not a case where evidence points in multiple directions, requiring you to choose between competing theories. This is a case of a man who killed his family in desperation and rage, then sought to escape justice through a web of lies that grew more elaborate with each telling. When those lies failed to protect him, he finally confessed, multiple times, to multiple officers. The confessions are detailed, specific, and corroborated by physical evidence. Ladies and gentlemen, by the time you have heard all the evidence, you will have no reasonable doubt about Timothy Evans' guilt. The Crown asks you to return the only verdict the evidence supports: guilty of murder. The jury listens, absorbing the narrative framework: confession, discovery, corroboration, the building blocks of certainty. Malcolm Morris, in his counterstatement for the defense, attempts to plant seeds of doubt that might grow during the evidence presentation. The defense will show that Timothy Evans is a man of extremely limited intelligence and literacy. He cannot read beyond his own name. He cannot write beyond his signature. He struggles to understand complex questions and often answers in ways that please the questioner rather than accurately reflecting the truth. He is vulnerable to pressure, confused by legal terminology, unable to understand the machinery arrayed against him in a formal police interrogation. His so-called confessions are the product of coercion, misunderstanding, and psychological pressure applied over many hours by experienced detectives who knew exactly how to extract statements from a vulnerable suspect. The defense will present an alternative theory that John Christie, the prosecution's star witness, is in fact responsible for these deaths. We will show that Christie had access to the Evans flat, opportunity to commit these crimes, and motive rooted in his offer to perform an illegal abortion. We will demonstrate that Christie had medical knowledge claims that were false, that his behavior around the time of the murders was suspicious, that his failure to notice two bodies in a 4 by 5 foot space he claimed to use daily defies credibility. We will prove that Evans, far from being a calculating murderer, is a confused and manipulated man who trusted the wrong neighbor, who was deceived about what happened to his wife, who gave confused statements under unbearable pressure, and who has been made a scapegoat for crimes committed by the very man testifying against him. Ladies and gentlemen, when you have heard all the evidence, when you have seen how vulnerable Mr. Evans truly is, when you have considered the suspicious proximity of Mr. Christie to these crimes, you will have reasonable doubt, and reasonable doubt requires acquittal under British law. That is what we ask of you, not certainty of innocence, but reasonable doubt about guilt. That doubt exists, and we will prove it to you. The courtroom weighs these competing narratives with the audience's instinct for the plausible. The prosecution's story seems clean, coherent, supported by the most powerful evidence any criminal case can have: confession. A man who confesses must be guilty. That is the cultural assumption, the legal presumption, the common sense conclusion. Why would an innocent person confess to murdering their own child? The defense's theory seems desperate, reaching, hard to believe. It requires the jury to accept that a respectable former constable is secretly a murderer, that he has framed his neighbor through elaborate manipulation, that police have been deceived by a criminal more clever than themselves. Who would credit such an implausible conspiracy? The prosecution asks jurors to believe what seems obvious. The defense asks them to believe what seems fantastic. The power dynamics in the courtroom already favor conviction before a single piece of evidence has been presented. This imbalance will only grow as the trial proceeds and the weight of confession evidence accumulates in the jury's collective consciousness. The prosecution begins constructing its case brick by brick. Detective Inspector James Black takes the stand first, recounting Evans's arrest and interrogation. He describes Evans's multiple statement, their shifting account, their ultimate confession to killing both wife and child. "Did Mr. Evans appear to understand the questions you were asking?" Humphreys inquires. "He appeared to comprehend, yes, sir. He answered questions appropriately." "Did you coerce him in any way?" "Absolutely not, sir. All questioning was conducted properly under the judge's rules." On cross-examination, Morris probes Evans's vulnerability. "Detective Inspector, would you describe Mr. Evans as intelligent?" "He's of limited education, certainly." "Can he read?" "Only his name, I believe." "Can he write?" "Only his signature." "Yet you read him lengthy statements and had him sign them." "That is correct, sir. That is proper procedure." "Did you explain every legal term, every implication, every consequence?" "We explained the charges and his rights under caution." The exchange highlights Evans's vulnerability but doesn't overcome the weight of signed confession. The jury sees a man who, however limited, understood enough to confess. Detective Sergeant Corfield describes the searches of 10 Rillington Place. The first search, he admits under questioning, was not exhaustive. Why not? Time constraints. Christie's assurances that nothing was amiss. The assumption that Evans was lying. But the second search proved thorough. They found the bodies exactly where Evans had indicated. "And how were the bodies concealed?" Humphreys asked. "Behind timber planks in the washhouse alcove, sir, stacked deliberately to hide the alcove from view." "Could someone stumbling upon this scene have missed the bodies?" "Easily, sir, if one wasn't looking specifically." Morris's cross-examination focuses on Christie. "Did Mr. Christie claim to use the washhouse regularly?" "He did, sir. He and his wife both claimed to access it for water, yet neither noticed 2 decomposing bodies in a 4-by-5-foot space." "They claim not, sir." "And you found this credible?" "We had no reason at that time to doubt Mr. Christie, sir." The implication hangs in the courtroom air. Christie's curious blindness to what lay feet away from his daily routine. But implications are not evidence. The jury needs more than suspicious inconsistencies. Dr. Donald Tier, pathologist, provides clinical testimony that chills the courtroom. He describes his examination of Beryl's body, strangulation by ligature, possible post-mortem interference, suggesting sexual motivation. He describes Geraldine's tiny body, manual strangulation, deliberate application of fatal pressure. Both deaths required sustained force. Both were unmistakably murder. In your professional opinion, Dr. Tier, could these murders have been committed by the same person? They share certain characteristics, yes. Both strangulations. Both concealed in the same location. Would these murders require particular strength? Strangulation requires determination more than exceptional strength, sir. An average adult could accomplish it. Morris attempts to use the sexual interference to suggest Christie's involvement, known in medical literature to accompany certain types of serial murders. But without direct evidence linking Christie, the testimony remains abstract, theoretical, unconvincing. Then John Reginald Halliday. Christie takes the stand, and the courtroom's attention sharpens. This is the moment the case pivots on, the credibility contest between the confused defendant and the respectable witness. Christie walks slowly to the witness box, moving with the deliberate care of a man whose body has been damaged by service to his country. His damaged voice requires the court's patience and creates an atmosphere of strained attention. Everyone must lean forward to catch his words. This physical necessity creates an intimacy, a sense that he is sharing painful truths with effort and reluctance, rather than performing calculated lies with practiced ease. He swears his oath on the Bible with appropriate solemnity. He sits carefully, arranging himself with the precision of someone accustomed to formal proceedings. He radiates quiet credibility, not the flashy confidence of a practiced liar, but the understated authority of someone telling truth reluctantly because duty requires it. His entire presentation suggests a man who wishes he didn't have to be here, who takes no pleasure in testifying against a neighbor, but who will do his civic duty because that is what respectable citizens do when called upon by their country's justice system. Christmas Humphreys leads him through preliminary questions designed to establish credibility before reaching the crucial testimony. "Mr. Christie, please tell the jury about your background and service to this country." Christie answers with careful detail, his quiet voice requiring jurors to concentrate on every word. He mentions his service in the Great War, fighting in France, suffering injuries from gas attacks that permanently damaged his vocal cords, and left him with respiratory problems that plague him still. He describes his time as a war reserve constable during the recent conflict, serving his community when younger men were away fighting. He explains his current employment as a clerk, his modest life, his long marriage to Ethel. Each detail adds another layer to the portrait of a respectable, patriotic citizen, a man who has sacrificed for his country, who has served in law enforcement, who leads a conventional life marked by duty and propriety. The jury absorbs this carefully constructed image. They see a man of sacrifice and patriotism, someone who has earned trust through service. When such a man testifies, his words carry weight that no amount of cross-examination can fully undermine. Mr. Christie, did you know Timothy Evans? Yes, sir. He lived above me with his wife and daughter. Describe your relationship with him. Neighborly, I suppose. We exchanged pleasantries. I tried to be helpful when he had questions. Did anything unusual occur in November 1949? Christie shifts slightly, as though the memory causes discomfort. On November 14th, Mr. Evans came to speak with me. He seemed agitated, upset. He told me he'd done something terrible. What did he say specifically? He said he'd killed his wife and baby. He'd strangled them both. He asked me what he should do. The courtroom stills. Here, delivered in quiet, damaged tones, is the heart of the prosecution's case. Confession to a neutral third party, corroboration of police statements, testimony from a man with no apparent motive to lie. What did you tell him? I told him he should go to the police immediately, sir. I urged him to confess, but he fled to Wales instead. Did you go to the police yourself? I considered it, sir, but I had no proof. I thought perhaps it was emotional rambling, that I'd misunderstood. When police came investigating, I told them everything I knew. Did you at any time assist Mr. Evans in concealing these bodies? Absolutely not, sir. I knew nothing of their location until police discovered them. Did you offer to perform an abortion on Mrs. Evans? Certainly not, sir. I have no medical training. I would never have suggested such a thing. Humphreys sits, satisfied. Christie has delivered his testimony with perfect credibility. Reluctant witness, patriotic citizen, man caught unwillingly in his neighbor's tragedy. Malcolm Morris rises for cross-examination, knowing this is his crucial moment. If he cannot shake Christie's testimony, Evans is lost. Mr. Christie, you claim Mr. Evans confessed to you on November 14th? Yes, sir. That's 6 days after the murders allegedly occurred? If that's the date, sir, yes. And you did nothing for 6 days? I urged him to confess, sir. What else could I do? You could have gone to police immediately. As I said, sir, I had no proof. It seemed like the ravings of an upset man. Morris shifts tactics. You claim you have no medical knowledge. Yet Mr. Evans testified you offered to perform an abortion. Mr. Evans is mistaken or lying, sir. Multiple witnesses will testify you claimed medical knowledge. I may have mentioned my first aid training from the war, sir. Nothing more. Your wife testified that you and she used the wash house daily for water, correct? Yes, sir. Yet neither of you noticed 2 bodies in a 4-by-5 foot space. I noticed the timber stacked differently, sir, but I assumed the workmen had left it. You're telling this jury that decomposing bodies gave off no odor you noticed? I have limited sense of smell, sir. Result of the gas attack. How convenient. Objection. Humphreys rises. Counsel is editorializing. Sustained, Judge Lewis rules. Morris continues, but Christie has answers for everything. Plausible, delivered with quiet authority, reinforcing his credibility with every exchange. The cross-examination fails to crack his testimony. If anything, his calm responses under pressure make him seem more trustworthy. The prosecution calls character witnesses. Christie's neighbors, who describe John as helpful, quiet, respectable. They call Ethel Christie, who corroborates her husband's account, who describes hearing loud arguments from the Evans flat, who noticed nothing unusual in November, despite daily trips to the wash house. They introduce Evans's signed confessions, reading them aloud to the jury. The shifting accounts, the admissions of guilt, the details only the killer would know. Each reading hammers another nail into Evans's defense. By the time the prosecution rests, their case seems insurmountable. Confession, corroboration, physical evidence, a clear timeline. What reasonable doubt could survive this weight of evidence? The defense calls Timothy Evans to the stand. He rises awkwardly, climbs into the witness box, faces the jury that will determine whether he lives or dies. Malcolm Morris guides him through his story. Meeting Beryl, their marriage, their move to Rillington Place, their financial struggles, Beryl's pregnancy. Timothy, did you kill your wife? No, sir. I never hurt Beryl. Did you kill your daughter? No, sir. I loved Geraldine. Then what happened? Evans struggles to articulate the events coherently. He describes Christie's offer to help with the abortion, his agreement, his absence from the flat, his return to Christie's devastating news, his belief that Geraldine would be cared for, his flight to Wales. Why did you confess to police? They kept asking and asking, sir. I was tired. I was confused. They said Christie told them things. I didn't understand what they wanted. I just wanted them to stop. Did they threaten you? They said it would go easier if I told the truth. I didn't know what the truth was anymore, sir. I just wanted to see Geraldine. When did you learn your daughter was dead? When the police told me they'd found her body, sir. That's when I knew Christie had lied about everything. Under cross-examination, Humphreys methodically destroys Evans' credibility. He highlights the shifting stories, the signed confessions, the implausibility of Christie's supposed guilt. Mr. Evans, you signed statements confessing to these murders, did you not? They read them to me, sir. I couldn't read them myself, but you understood what you were signing. I thought, they said if I signed, things would be better. Things would be better? You were confessing to murdering your wife and child. Did you think that would make things better? Evans stammers, unable to articulate the psychological pressure, the confusion, the vulnerability that led to false confession. To the jury, he seems evasive, caught in lies. Mr. Evans, you're asking this jury to believe that John Christie, a former constable, a war hero, a man of good character, is actually a murderer who has framed you? Yes, sir. Christie done it. Do you have any evidence of this beyond your own word? I know what happened, sir. That's not evidence, Mr. Evans. That's desperation. The cross-examination ends with Evans appearing dishonest, confused, grasping at implausible theories to escape just punishment. His own testimony, meant to save him, has instead confirmed suspicions of guilt. Morris calls additional witnesses attempting to establish Christie's suspicious behavior, neighbors who noticed Christie in the washhouse area around the time of the murders, workmen who contradicted Christie's timeline about the timber planks, but their testimony is fragmentary, their memories uncertain. Against Christie's authoritative composure, these half-remembered observations carry little weight. The defense presents expert testimony on false confessions, explaining how vulnerable suspects under sustained interrogation can confess to crimes they didn't commit. But this was 1950. Before such psychological understanding became widely accepted. To the jury, it seems like academic theory disconnected from the reality of Evans's signed statements. Morris delivers his closing argument with passion born of desperation. He hammers on Evans's vulnerability, Christie's suspicious proximity to the crimes, the investigative failures that left crucial questions unexamined. Members of the jury, the Crown asks you to believe that Timothy Evans, a man who can barely read, who struggles to articulate complex thoughts, somehow committed 2 calculated murders, successfully concealed them, then immediately fled to Wales and confessed to police. Does this make sense? Or does it make more sense that John Christie, a man with access to the flat, a man who offered to perform an illegal abortion, a man whose own wife somehow failed to notice 2 bodies' feet from her daily routine. Does it make more sense that he is responsible? The police investigated Evans thoroughly but never truly investigated Christie. They found what they expected to find, a confession from a vulnerable man, and stopped looking. I'm asking you not to make the same mistake. Look at the full picture. Consider reasonable doubt. Consider that the monster might not be the confused young man before you, but the calm, credible witness who pointed the finger. It is eloquent, impassioned, and ultimately insufficient. The jury has heard too many signed confessions, seen too much physical evidence, found Christie too credible to doubt. Christmas Humphreys rises for the prosecution's closing argument. His voice carries the weight of certainty, the confidence of overwhelming evidence. Members of the jury, the defense would have you believe an elaborate conspiracy. They would have you believe that a decorated war veteran, a former police constable, a man of impeccable character, is secretly a murderer who has framed his simple-minded neighbor. Why? For what possible motive? The defense cannot answer because there is no answer. The truth, ladies and gentlemen, is far simpler and far more tragic. Timothy Evans, faced with financial pressure and a second unwanted pregnancy, lost control. He killed his wife in a fit of rage. He killed his daughter to eliminate a witness, or out of despairing logic that she was better off dead. Then, realizing what he'd done, he panicked. He fled. He concocted stories. He confessed, then retracted, then confessed again, then blamed his neighbor. His confessions are not the product of coercion, but of guilt. Guilt that momentarily overcame his instinct for self-preservation. The physical evidence, the testimony, the confessions all point inexorably to one conclusion. Timothy John Evans is guilty of murdering his daughter Geraldine. The law requires you to return that verdict, and justice demands nothing less. The arguments conclude. Judge Lewis provides his summation, carefully explaining the law, the burden of proof, the requirement for moral certainty beyond reasonable doubt. His instructions favor the prosecution. He emphasizes the signed confessions, Christie's credible testimony, the defense's failure to provide convincing alternative explanations. The jury retreats to their deliberation room at 2:45 p.m. on January 13, 1950. 12 ordinary citizens, carrying the extraordinary burden of deciding whether a man lives or dies. They file out in silence, their faces reflecting the weight of responsibility. The courtroom empties into nervous waiting. Outside, journalists smoke cigarettes and speculate about how long deliberations will take. Some predict hours of careful weighing of evidence. Others suggest the verdict is obvious and will come quickly. Inside the courtroom's adjacent areas, Evans sits in the holding cell surrounded by guards, his face blank with exhausted incomprehension. He has sat through 3 days of testimony that painted him as a monster who strangled his wife and baby. He has heard Christie's devastating testimony delivered with perfect credibility. He has watched his own confused words read back to him as evidence of guilt. He no longer knows what to hope for. Malcolm Morris paces, reviewing in his mind what more he could have done, what arguments he might have pressed harder, what witnesses he should have called. He knows the case is lost, but holds on to a thread of hope that the jury might see through Christie's testimony. Christmas Humphreys, by contrast, appears calm and confident. He has prosecuted dozens of murder cases and knows when a conviction is certain. The confession evidence alone would be enough. Christie's testimony sealed it. The physical evidence corroborated everything. This is not a close case. This is a formality, the jury confirming what the evidence made obvious from the start. At 3:25 p.m., 40 minutes after retiring, the jury returned. 40 minutes to decide life or death. 40 minutes to weigh 3 days of testimony, multiple confessions, competing narratives about the character of the accused and the credibility of the key witness. 40 minutes to render judgment that will end a human life or restore it. The speed of deliberation speaks volumes. In complex cases where evidence points in multiple directions, juries deliberate for hours or days. When they return in less than an hour, it means they found the case straightforward, the evidence overwhelming, the verdict obvious. Evans, hearing that the jury is returning so quickly, likely understands what it means even through his limited comprehension. Quick verdicts favor the prosecution. Long deliberations suggest doubt, debate, difficulty reaching consensus. This jury found no difficulty. The ritual of verdict unfolds with terrible formality. All rise. The judge enters. The jury files to their seats. The foreman stands. Members of the jury, have you reached a verdict? We have, Your Honor. On the charge of murder, how do you find the defendant? Guilty. The word falls like an executioner's blade. Evans shows little reaction. Perhaps he doesn't fully comprehend what guilty means in this context. Perhaps he's simply too exhausted to feel anymore. Judge Lewis assumes the black cap, the cloth symbol of death sentence. Timothy John Evans, you have been found guilty of murder by a jury of your peers. The law prescribes only one sentence for this crime. You will be taken from this place to a lawful prison, and from there to a place of execution, where you will be hanged by the neck until you are dead. May the Lord have mercy upon your soul. Amen, intones the court chaplain. Guards lead Evans away. He turns once, looking back at the courtroom as though searching for someone who understands, someone who believes him. He finds only faces of certainty, certainty that justice has been served, that the guilty has been judged, that the system has worked. He was wrong. They were wrong, but no one yet knows it. Appeals are filed immediately. Malcolm Morris, joined by more senior counsel, argues before the Lord Chief Justice Lord Goddard, Mr. Justice Sellers, and Mr. Justice Humphreys that the trial was fundamentally unsafe, that Christie should have been more thoroughly investigated, that Evans's confession was unreliable, that reasonable doubt existed. On February 20th, 1950, the appeal court rejects these arguments. The conviction stands. The sentence stands. The execution date is set. March 9th, 1950. Pentonville Prison. Timothy Evans spends his final night in the condemned cell, attended by guards who watch him with mixture of professional detachment and human sympathy. He writes no final letter. He cannot write. He speaks little. He maintains to the end that Christie committed the murders. At 9:00 a.m., Albert Pierrepoint, Britain's most experienced executioner, enters the condemned cell alongside his assistant, Sid Durnley. The ritual they perform has been refined over generations to be swift and certain. They bind Evans's arms. They lead him the 13 steps to the execution chamber. They position him on the trap door. They place the hood and noose. Pierrepoint calculates the drop based on Evans's weight, precision meant to ensure instant death, not prolonged suffering. The lever is pulled. The trap falls. Timothy John Evans drops 8 feet and dies instantly, his neck broken by the calculated fall. Time of death, 9:02 a.m. The doctor confirms it. The death certificate is signed. Britain has executed a man for a murder committed by the witness who testified against him. John Reginald Halliday. Christie walks free. For 3 years after Evans's execution, Christie continues living at 10 Rillington Place, the house now infamous from the murder trial. The street, already notorious, slowly decays around him. Neighbors move away. Property values decline. The building itself seems cursed by association with tragedy. Christie loses his job at the post office, officially for minor infractions, but really because employers are uncomfortable with his connection to the Evans case. His marriage, never warm, sours completely. Ethel becomes increasingly difficult, increasingly aware that something is terribly wrong with her husband, increasingly a liability and a witness to too much. She knows things that Christie cannot allow her to continue knowing. She has lived in that house through the murders. She claimed to use the wash house daily without noticing bodies. Her testimony helped convict Evans. If she were ever to recant, to admit she knew or suspected more than she testified, the entire case would unravel. Christie cannot take that risk. In December 1952, he strangles Ethel Christie in their bedroom and hides her body under the floorboards of their front room. He tells neighbors and relatives that she's gone to visit family in Sheffield, that her rheumatism has worsened, and she needs a change of climate. He sells their furniture piece by piece to raise money for rent. He allows the flat to deteriorate. He begins the final, accelerating spiral of his killing spree. 3 more women murdered between January and March 1953. Rita Nelson, 25 years old, strangled and hidden in the kitchen alcove. Kathleen Maloney, 26, strangled and hidden beside Rita. Hectorina McLennan, 26, strangled and hidden with the others. All 3 concealed behind wallpaper Christie used to cover the alcove entrance, creating a makeshift tomb in his kitchen. The house becomes a charnel house. Rooms filled with bodies of women Christie gassed unconscious before strangling. His technique is practiced, refined through repetition. His concealment is methodical, but his judgment deteriorates. He becomes careless, sloppy, unable to maintain the facade of respectability that protected him for so long. In March 1953, Christie abandons 10 Rillington Place entirely, unable to pay rent, unable to maintain even the pretense of normal life. He becomes effectively homeless, sleeping rough near the Thames, living on the streets of London like thousands of other forgotten men in post-war Britain. New tenants move into the ground floor flat he vacated. They notice immediately that something is wrong. The smell, sweet, sickening, the unmistakable odor of decomposition. The walls seem odd. The kitchen feels wrong. One tenant, Beresford Brown, wants to install a bracket for a radio on the kitchen wall. He taps the wall to find a stud. It sounds hollow. He peels back a corner of the wallpaper. He sees something that shouldn't be there. He tears away more paper. He peers into the darkness behind with a flashlight. What he sees will haunt him forever. Naked bodies, partially decomposed, preserved by the enclosed space. 3 women staring back at him from death with empty eyes. He staggers back, drops the flashlight, runs screaming from the flat into the street. Police are called. They arrive within minutes. They enter the flat with extreme caution. Unsure what they're dealing with, they pull away the wallpaper completely. They find the 3 women Christie killed in early 1953. They search the rest of the flat systematically. They find Ethel under the floorboards. They excavate the small garden. They find more remains. 2 more women Christie had killed years earlier, buried in shallow graves. The house at 10 Rillington Place yields 6 bodies, 6 women murdered by one man over several years, and every single one strangled in the same manner as Beryl and Geraldine Evans. The forensic signature is unmistakable. The pattern is clear. And suddenly, 3 years after Timothy Evans was hanged for murdering his daughter, the truth becomes horrifyingly obvious to everyone paying attention. Christie is arrested days later, found living rough by the Thames. carrying nothing but a few coins, his identity card, and an old newspaper clipping about Timothy Evans's trial. He confesses to multiple murders during police interrogation. He confesses to murdering Beryl Evans, describing how he offered to help with abortion, how he used carbon monoxide gas from the coal jet to render her unconscious, how he strangled her while she was helpless. He denies killing Geraldine, but his denial carries no weight against his admission of Beryl's murder and his established pattern of strangulation. Christie's trial in June 1953 becomes a mirror image of Evans's trial 3 years earlier. Different defendant, same courtroom at the Old Bailey, same crimes discussed in testimony. Christie pleads not guilty by reason of insanity. His defense counsel argues he's a maniac, a madman beyond moral responsibility, someone whose mental illness drove him to commit horrific acts. The prosecution, led by Attorney General Sir Lionel Heald, argues that Christie knew exactly what he was doing, that his murders were calculated and deliberate, that he carefully concealed bodies and lied to investigators, proving he understood the wrongfulness of his actions and therefore deserves no mercy from an insanity defense. The jury deliberates 80 minutes, longer than Evans's jury deliberated, but not by much. They reject the insanity defense and find Christie guilty of murder. Mr. Justice Finnemore sentences him to death with the same ritualistic formality that condemned Evans. Christie, like Evans before him, will hang. On July 15, 1953, Albert Pierrepoint returns to Pentonville Prison. He has hanged over 400 people in his career as Britain's chief executioner. He has hanged innocent men before, though he didn't know it at the time. Today he knows. Today he hangs John Reginald Halliday Christie in the same execution chamber where Evans died, using the same trapdoor, following the same ritual, employing the same calculated precision. Pierrepoint will later write in his autobiography that this execution weighed on him more than most, not because it was technically difficult, but because he had participated in executing an innocent man 3 years earlier, and now executes the real killer. The symmetry is terrible, the justice hollow and belated, the irreversibility absolute. Christie drops at 9:00 a.m., time of death 9:02 a.m., the same 2 minutes that killed Evans. Britain has now executed both the innocent and the guilty, and the machinery that failed to distinguish between them at trial remains largely unchanged. But the public will not let the case rest quietly. Journalists, led by the tenacious and thorough Ludovic Kennedy, begin investigating every aspect of the Evans case. Kennedy's exhaustive research for his book 10 Rillington Place exposes the investigative failures, the psychological pressure that produced coerced confessions, the rush to judgment that overlooked obvious warning signs. He interviews witnesses who were never called at Evans' trial. He examines documents that were never presented to the jury. He reconstructs the timeline with meticulous care. He constructs a devastating case that Evans told the truth in his second police statement, that Christie performed the abortion, killed Beryl when things went wrong, or perhaps deliberately, manipulated Evans into fleeing London, and testified falsely to save himself when police investigation focused on the house. Kennedy demonstrates that virtually every element of the prosecution's case against Evans was either unreliable or explainable by Christie's guilt. Kennedy's 1961 book becomes an immediate sensation, sparking parliamentary debates and intense public outcry. How could this have happened in Britain? How could British justice, renowned worldwide for its fairness, its protections for defendants, its careful procedures, have executed an innocent man on the testimony of the actual killer? How could police, prosecutors, judge, and jury all fail so catastrophically? The government, protective of institutional reputation and resistant to admitting systemic failure, orders a cursory inquiry that incredibly upholds the guilty verdict and concludes Evans was still probably guilty of both murders despite Christie's confession. The establishment closes ranks, unwilling to acknowledge that the machinery of justice can produce such catastrophic errors. But the pressure continues mounting from multiple directions. Harold Evans, no relation to Timothy, editor of the Northern Echo newspaper in northern England, joins Kennedy in campaigning tirelessly for justice. They form the Timothy Evans Committee, gathering evidence, lobbying politicians, keeping the case in public consciousness. Liberal MP Herbert Wolfe of Darlington adds crucial political pressure. The case becomes a cause célèbre, a symbol of capital punishment's ultimate danger, irreversible error that kills the innocent. In 1965, under sustained public pressure and growing acknowledgement that the original inquiry was inadequate, Home Secretary Sir Frank Soskis, finally orders a comprehensive inquiry chaired by High Court Judge Sir Daniel Braben. For months throughout 1965 and into 1966, Braben examines every document from the original investigation and trial, interviews every surviving witness who can shed light on the events, reconstructs the timeline with forensic precision, weighs the competing versions of events against each other. His inquiry is thorough, methodical, professional. His 1966 report reaches a peculiar and legally incoherent conclusion. Evans probably did not murder his daughter Geraldine, but might have killed his wife Beryl in a domestic dispute. It's a finding that satisfies virtually no one. Legally incoherent because the prosecution argued at trial that both murders were committed by the same person as a single murderous act, and Evans was convicted specifically of Geraldine's murder, which Braben now says he probably didn't commit. The report seems designed to give the government political cover to pardon Evans without fully admitting the scope of the injustice. But the Braben report's careful equivocation proves enough for Home Secretary Roy Jenkins to recommend a posthumous royal pardon for Timothy Evans, focusing on the Geraldine murder for which he was convicted and executed. On October 18, 1966, 16 years, 7 months, and 9 days after his execution, Evans receives the pardon. It is a formal acknowledgement that the conviction was unsafe, that Evans should not have been hanged, that justice failed catastrophically. Evans's body is exhumed from Pentonville Prison's unmarked grave where executed prisoners were buried in quicklime, and reburied with dignity in St. Patrick's Roman Catholic Cemetery in Leytonstone. He finally receives a proper gravestone bearing his name, recognition in death that was denied him in life. The Evans case, alongside the wrongful executions of Derek Bentley in 1953 and Ruth Ellis in 1955, fundamentally reshapes British attitudes toward capital punishment and forces a national reckoning with the limits of justice. Christmas Humphreys, the prosecutor who secured convictions in all 3 cases, never publicly acknowledges error or expresses regret. He prosecuted Evans, securing his execution. He prosecuted Bentley, an intellectually disabled 19-year-old, hanged for words he allegedly said while his accomplice fired the fatal shot. He prosecuted Ellis, a woman who killed her abusive boyfriend and became the last woman executed in Britain. 3 people hanged based on Humphrey's advocacy, 2 certainly wrongful, 1 highly questionable given the circumstances of domestic abuse. The prosecutor who believed in karma and duty, who saw himself as an instrument of cosmic justice, became instead a symbol of the system's capacity for catastrophic error. Public opinion, already shifting against capital punishment through the 1950s, crystallizes around these cases into a conviction that execution must end. If the system could execute Timothy Evans on the testimony of the real killer, if it could hang Derek Bentley for words he allegedly said, if it could execute Ruth Ellis for killing her abuser, what protection did anyone have? What confidence could exist in irreversible punishment when judges were dying during trials, when prosecutors prioritized convictions over truth, when vulnerable defendants faced overwhelming machinery without adequate protection? The Homicide Act 1957 attempts a compromise, restricting capital punishment to specific categories of murder, a half measure acknowledging public concern while maintaining the death penalty's existence for certain worst murders. But the restrictions prove untenable in practice. The categories seem arbitrary and inconsistent. The executions that continue under the new law seem capricious and unfair. The Evans case haunts every death sentence, every appeal, every execution that occurs after 1957. On November 9, 1965, Parliament votes to suspend capital punishment for murder for 5 years as an experiment. The suspension proves permanent. In 1969, after 5 years without execution, Parliament makes abolition permanent through another vote. Britain, having hanged its last prisoners in August 1964, formally abolishes the death penalty for murder. The machinery that killed Timothy Evans is dismantled. The execution chamber at Pentonville becomes a storage room. The rope and trap that ended Evans's life become historical artifacts displayed in museums. The position of executioner is abolished. Albert Pierrepoint retires, spending his final years running a pub and contemplating the men he hanged, including Evans, whose innocence he came to accept. But abolition cannot resurrect the dead. It cannot give Timothy Evans the 25 years stolen from him or the decades he might have lived. It cannot restore Geraldine to life or undo Beryl's suffering. It can only ensure the mistake won't be repeated in Britain that no future Timothy Evans will hang for another man's crimes on British soil. In January 2003, more than half a century after Evans' execution, the Home Office formally acknowledges what had long been obvious to anyone examining the evidence fairly. Lord Brennan QC, acting as independent assessor reviewing the case, declares unequivocally, the conviction and execution of Timothy Evans for the murder of his child was wrongful and a miscarriage of justice. There is no evidence to implicate Timothy Evans in the murder of his wife. She was most probably murdered by Christie. The assessment goes further than the Brabham report, rejecting its suggestion that Evans killed Beryl while Christie killed Geraldine, an illogical splitting of responsibility that ignored the forensic and circumstantial evidence linking both murders to Christie. The government awards compensation to Evans' half-sister Mary Westlake and his sister Eileen Ashby, money that cannot restore what was lost, but represents formal acknowledgement of the state's responsibility for their brother's wrongful death. The payment is ex gratia, made without admission of legal liability, but the accompanying statement makes the moral responsibility clear. The state killed an innocent man. The machinery of justice failed at every level. Compensation, however inadequate, acknowledges that failure. The case endures in British legal and cultural consciousness as a watershed in criminal justice history. Law schools study it as an example of multiple systemic failures operating simultaneously. Inadequate defense investigation, coerced confession from vulnerable suspect, over-reliance on witness credibility, rush to judgment, insufficient appellate review, capital punishments, irreversibility. Police training now includes extensive coverage of false confession psychology, understanding of suspect vulnerability, thoroughness in investigation that doesn't stop at the first plausible suspect. The requirement for corroboration of confessions strengthened. The rights of defendants expand significantly. The protections for vulnerable suspects multiply. Appropriate adults present during questioning, recording of interviews, limitations on interrogation length and techniques. Every reform acknowledges implicitly what Evans's case proved. The system can fail catastrophically, and when capital punishment exists, failure means death. Forensic science advances partly in response to cases like Evans's, seeking objective evidence that doesn't rely on testimony alone. DNA analysis, unknown in 1950, now provides certainty that confession alone never could. Modern investigators understand that credibility is not reliability, that respectable appearance masks evil as easily as disreputable appearance masks innocence. The lessons are written in blood. Evans's blood, Beryl's blood, Geraldine's blood, the blood of all Christie's victims who might have been saved if police had investigated him as thoroughly as they investigated the man he framed. 10. Rillington Place no longer exists physically. The entire street was demolished in the 1970s as part of urban redevelopment, the houses razed, the ground cleared, the cursed location erased from London's geography. Where Timothy Evans' family lived and died, where John Christie committed his murders, where British justice suffered one of its darkest failures, there now stands modern construction, the past buried beneath concrete and progress. The street itself was renamed Ruston Close, an attempt to escape the infamy that made Rillington Place synonymous with horror. No plaque marks the location. No memorial acknowledges what happened there. The physical erasure is complete, but memory persists in other forms. Ludovic Kennedy's book remains in print, introducing new generations to the case's details. The 1971 film adaptation, starring Richard Attenborough as Christie and John Hurt as Evans, brings the story to cinema audiences worldwide. Documentaries revisit the evidence periodically, each generation discovering anew the case's capacity to shock and disturb. Academics analyze the systemic failures from multiple perspectives: legal, psychological, sociological, historical. The case becomes shorthand in criminal justice discussions for capital punishment's ultimate danger, the execution of the innocent. The questions Evans's case poses remain urgent beyond Britain's borders. How do we protect the vulnerable from their own confused statements? How do we ensure defense counsel investigates rather than assumes guilt? How do we prevent credible-seeming monsters from manipulating justice? How do we build systems that acknowledge their own fallibility? And when punishment is irreversible, how can we ever be certain enough to take a life? Britain answered by abolishing capital punishment. The death penalty ended because cases like Evans's proved that certainty is an illusion, that credibility can deceive fatally, that the state's power to punish must be limited by its capacity for error. Other nations continue wrestling with these questions, executing defendants whose cases contain disturbing echoes of Evans, confused confessions, questionable testimony, inadequate defense, hurried justice. The machinery of death continues operating in much of the world, despite the lesson Evans's case teaches clearly, that certainty is impossible, that mistakes are inevitable, that execution cannot be undone. Timothy John Evans was 25 years old when he died on March 9, 1950. He left no children beyond the daughter murdered alongside his wife. He left no writings. He couldn't write beyond his signature. He left no eloquent last words. He had neither eloquence nor perhaps faith that words would matter to those determined to kill him. What he left was a case study in injustice, a warning carved in judicial failure, a ghost that haunts every capital case in every courthouse that still sentences people to death. In the Old Bailey's Court Number 1, where Evans was tried and convicted, proceedings continue 75 years later. Judges sit where Mr. Justice Lewis sat, his health failing even as he pronounced sentence. Prosecutors argue where Christmas Humphreys stood with his Buddhist beliefs and unshakable certainty. Defendants face judgment where Evans faced his doom, trembling and confused. But the black cap is gone, abolished with the death penalty. The ritualistic pronouncement of death sentence is gone. The finality that killed Evans cannot kill again in Britain. The case asks us to imagine counterfactuals. What if the tenant hadn't knocked on that wall in March 1953? What if Christie's garden hadn't been excavated? What if Christie had died of natural causes, taking his secrets to the grave? Timothy Evans would remain in history as a child killer, his name synonymous with domestic horror, his grave unmarked and unacknowledged, his memory reviled. Only accident, a tenant wanting to install a radio bracket, exposed the truth 3 years after Evans' execution. How many Timothy Evanses, we must wonder, lie in unmarked graves around the world, their innocence never discovered, their executions never questioned, their names forever stained by crimes they didn't commit? The question has no answer, only the terrible acknowledgement that when execution is possible, wrongful execution is inevitable. When the state claims the power to kill in law's name, it claims the power to kill mistakes alongside guilt. The last word belongs to the victims. All the victims of 10 Rillington Place. Beryl Evans, 20 years old, who sought help in desperation and found a monster. She trusted the wrong neighbor and died helpless under his hands, gassed unconscious and strangled while her husband was away. Geraldine Evans, 14 months old, who knew nothing of her parents' troubles, of Christie's evil, of the machinery that would execute her father for her murder. She was an infant who died because Christie could not allow her to grow old enough to speak about what happened in that flat. The 3 women Christie killed in early 1953, Rita Nelson, Kathleen Maloney, Hectorina McLennan, whose names deserve remembering even as history focuses on Evans's wrongful execution. They died because Christie remained free to kill, because executing Evans didn't stop the real murderer, because justice's failure was catastrophic for multiple victims. Ethel Christie, who lived with a monster for decades, who may have known or suspected more than she ever testified, who died when she became inconvenient to her husband's continuing freedom, and Timothy Evans himself, victim of his own trust, his own vulnerability, his own society's rush to judgment and its machinery of irreversible punishment. For them, justice came too late, or not at all. Beryl and Geraldine got no justice. Only belated acknowledgement that their killer's testimony hanged an innocent man. The 1953 victims got justice only in Christie's execution, but that came 3 years after Timothy Evans's wrongful death. 3 years during which Christie remained free to kill because the system had already solved the Rillington Place murders by executing the wrong man. Ethel got no justice, her murder overshadowed by her husband's more sensational crimes, her complicity in Evans' conviction forever debated. Timothy got a pardon 16 years posthumous, a compensation payment to sisters who mourned him, and a place in history as the innocent man whose case changed Britain forever. The courtroom where it happened still stands, its wood paneling still dark with age, its benches still worn by decades of use. The prison where Evans died still operates, though the execution chamber is sealed and silent. The street where the murders occurred is gone, demolished and renamed, but the case remains. In law books and films, in collective memory and legal reform, in every argument about capital punishment, in every warning about certainty versus doubt, in every recognition that justice systems built by fallible humans must acknowledge their capacity for catastrophic error. On that January day in 1950, When the jury deliberated 40 minutes before condemning Timothy Evans to death, they believed they were serving justice. They believed the evidence was overwhelming. They believed the credible witness, dismissed the confused defendant, trusted the system that presented them with what seemed like a clear narrative. They were wrong. 40 minutes to decide. 16 years to acknowledge the error. An innocent man executed in the interval. 3 more women murdered because the real killer walked free. That is the legacy of 10 Rillington Place. That is the lesson of Timothy Evans. That is the question. Britain answered by abolishing the death penalty. Can we ever be certain enough to kill? The answer, bought with Evans' life and written in the blood of all Christie's victims, is no. When execution is possible, innocence dies alongside guilt. When the machinery of death operates, it grinds the vulnerable first. When certainty becomes dogma, truth becomes its first casualty. The courtroom secrets of 1950 are secrets no longer. They are warnings, written in the judicial record, carved into legal reform, remembered by every generation that studies how justice can fail catastrophically. They are the ghosts that haunt every courthouse where capital punishment remains, asking the unbearable question, how many more Timothy Evanses will die before the lesson is learned, that some mistakes cannot be corrected, that some sentences cannot be reversed, that some certainties are illusions, and that the ultimate punishment requires impossible certainty that human judgment can never achieve. The trial that changed Britain ended with a death sentence. It endures as proof that death sentences must end. In that courtroom, on that day, with that verdict, rushed, certain, wrong, Britain executed justice alongside Timothy Evans. Only by abolishing execution could justice be resurrected. That is the terrible, essential truth this case teaches. That is the secret the courtroom finally revealed. 75 years after Timothy Evans's execution, his case remains a touchstone for discussions of justice, fallibility, and the limits of state power in democratic society. The physical evidence is long gone, destroyed, lost, scattered across time and institutional memory. The witnesses are dead. Evans, Christie, Barrell, the police officers, the judge, the prosecutor, the defense attorney, the jury members. Even the executioner who hanged both Evans and Christie has passed. The building where the murders occurred is demolished and replaced. But the questions live, as urgent today as in 1950. In every courtroom where someone faces capital charges, Evans's ghost whispers warnings. In every interrogation room where a vulnerable suspect gives a confession, his case stands as cautionary tale. In every moment when society must choose between vengeance and mercy, between certainty and doubt, between justice and its terrible opposite, his name reminds us of costs we cannot afford to pay. Timothy Evans died saying, Christie done it. He was right. Christie had done it. Christie had killed Barrell. Christie had killed Geraldine. Christie had manipulated Evans. Christie had lied on the witness stand under oath. Christie had walked free while Evans hanged. And the system, designed to discover truth, to protect the innocent, to punish only the guilty, had failed at every level. That failure is the enduring lesson. Not that evil exists. We know evil exists. Not that people lie. We know people lie convincingly. But that systems built to detect lies and defeat evil can themselves become instruments of injustice when they operate without sufficient humility, without adequate protection for the vulnerable, without willingness to acknowledge doubt and the possibility of error. Britain learned. The death penalty ended. The reforms came. The protections increased. But the lesson extends beyond Britain, beyond capital punishment, to every justice system everywhere. That certainty can be false. That credibility can deceive fatally. That confessions can lie. That 40 minutes is too short to deliberate a life. That execution is too final for fallible judgment. That sometimes the monster testifies for the prosecution while the victim sits in the dock awaiting death. These are the secrets the Old Bailey's courtroom revealed. These are the truths purchased with Timothy Evans's life. These are the warnings that echo still whenever justice contemplates irreversible punishment, whenever society chooses death over doubt. The courtroom has seen thousands of cases since January 1950, but one case changed everything. The case of the confused young man who couldn't read his own confession, who trusted the wrong neighbor, who told the truth but wasn't believed, who died innocent while the guilty watched, who became Britain's ghost, haunting every death sentence, demanding an answer to the question he never got to ask. If you can execute an innocent man on 40 minutes deliberation, how can you ever execute anyone at all? Britain's answer was abolition, complete, permanent, irreversible. Timothy Evans's wrongful execution alongside Derek Bentley's and Ruth Ellis's questionable hangings, created such overwhelming public revulsion that Parliament had no choice but to act. The death penalty was suspended in 1965 and permanently abolished in 1969. Britain joined the growing list of nations that recognized a fundamental truth. The state cannot be trusted with the power to kill its own citizens when error is inevitable and execution is forever. History's answer is memory, preserved in books, films, legal reforms, and the collective consciousness of a nation that learned its lesson in the cruelest way possible. Justice's answer is reform. Protections for vulnerable suspects, recorded interrogations, requirements for corroboration, recognition of false confession psychology, and above all, abolition of irreversible punishment. But the question remains urgent for every nation that still executes. Will you learn from Britain's mistake, or must you create your own Timothy Evans? Will you wait until you've killed an innocent person? Or will you abolish execution before that irreversible tragedy occurs? How many wrongful deaths are acceptable before you acknowledge that certainty is impossible and execution must end? The answer should be 0. The answer should be learn from Britain. Learn from Timothy Evans. Learn that when you give the state power to kill, you give it power to kill mistake. And some mistakes destroy not just the innocent who die, but the very idea of justice itself. The trial that changed Britain waits in history, ready to teach again. Whether we learn is the test of our own justice, the measure of our own mercy, the judgment of our own certainty. Timothy John Evans was hanged, March 9th, 1950, innocent. John Reginald Halliday Christie was hanged, July 15th, 1953, guilty. The death penalty in Britain ended permanently in 1969, abolished because of cases like Evans's. His wrongful execution saved countless future lives by proving the death penalty's fatal flaw. It kills the innocent alongside the guilty. Some secrets, once revealed, change everything forever. Timothy Evans's secret changed British law, ended state execution, and stands as eternal warning. If your justice system can make this mistake, it will make this mistake, and execution allows no corrections. For every nation that still executes, Timothy Evans asks, how many innocent deaths are you willing to accept? Because if the answer is 0, then execution must end. If the answer is any number above 0, then you have already admitted your system values vengeance over justice, finality over truth, and political expedience over human life. Britain chose 0. Britain chose to end execution rather than risk another Timothy Evans. What will your nation choose?